Some 30 million people a year in the U.S. are prohibited from changing jobs to work for perceived competitors, but that may no longer be the case. Last week, the Federal Trade Commission banned so-called non-compete agreements in all but a few cases. And here to talk about the opportunities and implications is James Poindexter. He's a labor and employment lawyer here in Jacksonville. Been on the program before. Welcome back, James.
Thanks for having me.
I want to start. I want to get to the recent FTC ruling in a minute, but I want to start by asking, because this really blew my mind, that employees of Jimmy John's were once required to sign non-compete agreements, meaning that they could not work at a competing sandwich shop within 3 miles of a Jimmy John's for at least 2 years.
That's right. So it's an example I use a lot to explain how non-competes, which were intended to restrict unfair competition, have really been overly applied by businesses to restrict even fair competition. I think for someone who's making a sandwich at Jimmy John's behind plated glass while we all stand there and watch, what's the trade secret? What exactly are they preventing their competitors at Subway from knowing that couldn't be gleaned from any member of the public? And I think that's why New York and Illinois, the Attorney General stepped in and sued and reached an agreement that the franchise could no longer do that.
And so that has been litigated away. Although I saw at one time there was a study done that found that basically it meant if you worked at a Jimmy John's, there would be 6,000 square miles in 44 states in the District of Columbia where you could not work, an effective work blackout, and that someone who'd worked at a Jimmy John's couldn't work in a similar role in the entire city of Tuscaloosa.
Yeah,
Alabama.
And that's where a lot of this comes down, is it wasn't necessarily within 2 or 3 miles of your Jimmy John's. It was from any franchise location. Remember, this isn't a chain. It's not like the employees would go and travel from store to store and work like you see in some other industries. Again, what exactly is the Coca-Cola secret recipe at Jimmy John's that they're so desperate to prevent?
So let's talk about what happened last week. The Federal Trade Commission issued this ruling. How long has it been in the works, and what are some of the implications?
Sure. So over a year ago, the FTC announced that they were considering this. We actually saw a similar memorandum come out of the National Labor Relations Board over a year ago. And they invited public comment. They proposed the rule just like they are allowed to do and like they're required to do with their delegated authority from Congress. You can imagine the outpouring of comments that they received from businesses on one side, from industry experts on the other side, and ultimately released this final rule. So it doesn't go into effect for 120 days from when it was published. So it's been about a week now. So we're waiting to see if an injunction gets entered to stop it, which I'm anticipating at this point, and then we'll see it litigated, most likely all the way to the Supreme Court.
So we talked about the Jimmy John's example. That's kind of an outlier, but who typically is covered by non-compete agreements?
Sure. So I can speak to the law here in Florida, and the law in Florida, the way it's written is that all restraints on trade, such as non-compete agreements, are illegal. That is the way the law is written. There is a narrow exception that's very narrow that's supposed to apply to only those who have what is called a legitimate business interest. So access to trade secrets and extremely confidential information, very close relationships with customers, the types that would cause them to be able to pull customers away from someone. Goodwill, specialized training is another one, highly specialized training, not just on the job. This is where the copy machine is. This is where the coffee maker is. And so the law is really written in a way that's supposed to say, these are anti-competitive. These are potentially violations of the antitrust statute. It's bad for the economy. It's against the law unless you fit within this narrow exception. And of course, the way industry has done it is everybody fits within that narrow exception, not just those people who could leave with the Rolodex that could sink the company within 6 weeks of departing.
I mean, and the idea behind this would be, if you're developing a product, for instance, with another person, and the day before it launches, they leave and start their own company and launch the identical product, or some kind of really, being able to peel away clients, for instance, if you're, have as you say, a Rolodex of people, and by leaving, essentially take away business from the place you left.
That's right, and that's the academic argument behind it. Now, where the rubber hits the road, California has effectively outlawed all non-competes and has been that way for a long time. I don't think anybody would say that they're having trouble coming up with trade secrets and that sort of thing over there, because there's other laws on the books. For instance, there's the Defend Trade Secrets Act, which prevents you from stealing trade secrets. That's already established as a valid law that restrains trade that's outside of non-competes.
That's a federal law?
There's a federal law on that. There's one in Florida.
What does it provide for?
So it says, look, if you have something that's truly a trade secret, you can't engage in nefarious activity in order to steal that trade secret away from a company, whether it's corporate espionage, and those are the types of things. But you can imagine an employee who copies the schematics for the new technology and goes down the street to the competitor is going to find themselves on the business end of a lawsuit. And so those laws are already on the books. There's duty of loyalties that have been known in Florida law long before the non-compete statute existed, where an employee owes a duty to their employer not to do anything that harms them while they're employed there. Confidentiality provisions. There's other tools in an employer's tool chest other than just restricting competition.
If you're just joining us, we're talking about the impacts of a new ban on non-compete clauses that was approved last week by the Federal Trade Commission. We're talking with labor lawyer James Poindexter, and if you have questions or comments, you can call us at 904-549-2937. You can also email firstcoastconnect@wjct.org, or you can reach out on social. James, I entered the broadcast side of this industry, about 15 years ago after working in print for a long time, and I was really surprised to see that there are non-competes very widely accepted in that industry. And it seems that it makes some sense, for instance, if you were like an anchor and you were going to switch from one station to the neighboring station, that would be confusing and upsetting, I guess, to people at the old station. But why so broadly in an industry like that?
So on the one hand, I think we've been sort of trained to believe that, right? We've sort of been conditioned to say, yes, that's unfair, that someone could leave and take their personality that's been built up in the community and go and use it with a competitor. But isn't that good for the economy? The idea that if I'm fed up with what's going on at this employer, whether it be low wages, bad working conditions, or in some cases, illegal conduct, that I can now say, okay, I'm going to leave this bad business and go work for a good business and make more money and work for an ethical company. And that's how the market is supposed to work itself out. The way these agreements are written instead say, no, you're stuck working for this illegal company or this unethical company, or you have to go find a whole new career at whatever stage of life you're in. And quite frankly, it puts the burden back on the employers to want to attract good people, to want to keep a good culture climate. And I think to a certain degree, that's the pushback that we're getting from the business community, is saying, we like being able to restrict the ability of employees to leave just because they're unhappy or they want to negotiate better terms. And I think that's where the National Labor Relations Board stepped in.
And so the pushback that this has received, I think even before it was approved, and it was a close vote, we should say, 3-3.
3-2, I think.
3-2. I'm sorry.
Something like that. Yeah. It was because, the presidents get to appoint members of the commission. And so President Biden was able to appoint some new folks, and then, the vote was pretty much on party lines. So.
But even before that happened, the U.S. Chamber of Commerce had said that they were going to sue, and I believe they did within 24 hours or something.
They did. Essentially, the next day, they filed a suit in Texas, and they have not announced that they're seeking an injunction yet, but they've got plenty of time to file a motion for an injunction, which would effectively stop the law from going to effect.
And what is the nature of their claim?
Great question. So there's sort of two principles here. This was not something that was passed by Congress, and the Constitution makes it fairly clear that, when you're regulating, interstate commerce, that's something that Congress is entitled to do. Now, there is a delegation of congressional lawmaking authority and rulemaking authority to administrative agencies. The FTC is one of those agencies, and the FTC was really established to deal with antitrust laws and to write regulations to prevent monopolies from coming back into our economy and wreaking havoc like they did early on. And so the challenge from the Chamber of Commerce is saying they exceeded that delegated authority, that they went beyond what Congress has enabled them to do by touching on this question.
We have a call from Daniel in San Marco with a question. Good morning, Daniel. Go ahead. You there, Daniel?
Can you hear me?
Yep, go ahead.
Okay. So my question was, if this new FTC rule holds up, is there any thinking that it could be retroactively applied to workers who are already under contract with non-compete clauses in their contract?
Good question, Daniel.
Great question. So the law or the rule specifically addresses that. Anybody who has a non-compete in effect right now, an employer is actually required to send them a letter or notify them that their non-compete will not be enforced. The only non-competes, the only exception to that is for management employees who make more than about $150,000 a year, and those are only going to be effective if they were entered into before the date goes into effect.
So the FTC estimates that 18% of the U.S. workforce is covered by non-compete agreements. They say that's 30 million people, or about 1 in 5. And I was shocked to see that it's that many.
And I think that speaks to why this came out. I mean, and again, you can imagine some situations where these types of agreements might be necessary. And I think if employers were a little bit more judicious in the way that they had used them, we wouldn't be here. But instead, we are having people who are entry level hourly employees who are having to sign these types of agreements, or in industries where there really is no legitimate interest, but it's just a way of preventing good old-fashioned competition that's good for the economy, that they're seeing the administrative blowback here.
And what is the argument? Is it purely economics that the FTC is saying? I mean, I've seen an estimate that they believe that it's would increase worker earnings over the next decade by almost $500 billion.
Right. And I think that they're saying what they're suggesting there, and a lot of it's hypothetical, and we'll have to see, but a lot of people are feeling trapped. I consult with people all the time who work for an employer, have thought about taking a job that may pay them more or give them better benefits, but they've got this non-compete, and they want to know what their options are. Florida is one of the worst states for employees when it comes to non-competes. Our statute is really one of the harshest in the country. A New York appellate court actually in an opinion wrote that it was truly obnoxious the way that it was written. It offended public policy in New York, and they're not the only state who has declined to enforce Florida law when it comes up in a contract.
I'm not clear, though. I thought you said that Florida law explicitly prohibited these.
Florida law explicitly prohibits it, but it has that narrow exception. And what's written into that exception that allows employers to enforce non-competes, they've deemed to be obnoxious. One of the things is the statute specifically states that a judge looking to enforce a non-compete cannot consider the impact that enforcement will have on the individual, so their ability to live and make a living, essentially. The judge has to completely ignore the impact that it has on the person.
That's fascinating. So when someone comes to you and they have, they're under a non-compete, what advice do you give them?
So there's a few different tools. One is let's evaluate it and see if it'll actually be enforced. Does it fit within that narrow exception? What are the defenses? And then once you go through the defenses, do we say, okay, take the risk, go and then try your hand if they sue you and you raise your defenses, and that's what litigation is for. The other side is to go to a judge proactively and try to get a declaratory judgment, declaring that it's unenforceable based on whatever the defenses are or if it exceeds what the statute permits.
When it would be undefensible, I mean, what would a judge be looking at if they're not allowed to look at, for instance, how it might impact your professional career?
Sure. So again, it's the employer's burden to prove that one or more legitimate business interest exists, right? So for instance, if I have the Jimmy John's employee, well, what's the legitimate business interest? Did they receive some kind of specialized training? Did they do they have personal relationships with their customers that they're going to take with them to Subway? What exactly are they asserting? And I think Jimmy John's probably had a tough time coming up with that, which is why they had to end their practice of using them. So that's what you're evaluating: is what's the interest.
And how often do employers sue if somebody just disregards? Because I know that that does happen. People say, "Well, I'm not going to observe it. I'm going to go do what I want to do."
Right. It's a big part of our practice. We are constantly in litigation with clients over these types of issues,
because employers do come after them.
Employers do, and oftentimes it's a David and Goliath situation. So it may not even necessarily be that they have a very bulletproof argument, but they know that they can afford the litigation. And if they can get a temporary injunction forcing the new employer to fire the employee, how is that employee going to continue to litigate it?
And I would guess if the litigation stretches out long enough, it basically obviates the waiting period. I mean, very often that's like a 6 month, is it?
2 years is, in Florida, 2 years is presumptively reasonable. So, but to your point, even then, yes, we have had these cases go on appeal long past the 2-year mark. And at that point, it's who's going to win because the winning party gets their attorney's fees.
So the lawsuit that was filed, considered in sort of a friendly appellate circuit, right, in Texas.
That's right.
And you would expect that they're going to seek an injunction. What happens then?
So if a federal judge puts in place an injunction, then the case would be heard on its merits at the trial level. Again, there's a couple of theories here that are going to be at play. There's the major questions doctrine, which is something that the Supreme Court has recently put into place that says when an administrative agency is making a rule that impacts a major economic issue or a major political issue, that it naturally exceeds its authority. That has to be left to Congress. And so that's what the Chamber of Commerce is going to be arguing. On the other side, the administration is going to be arguing, no, this is under what's called Chevron deference, which is a Chevron case that went to the Supreme Court that said when an agency has a delegated authority, their interpretation of that authority, so long as it's reasonable, the court's going to give deference to it. So we're going to see those two issues, I think, really come together and clash.
Even Chevron's being challenged at the Supreme Court, though.
Chevron is being challenged, and it looks like that may be beaten back a little bit.
Well, it's a fascinating issue, and I appreciate you being here to answer our questions. James Poindexter, thank you so much.
Happy to be here. Thank you.